Item number 3.
None of dismissed.
Item number 4.
Same order.
Item number 5.
May I please, your lordship. In this case, I have the limited grievance, lordship. The petitioners are the inhabitant of the locality and
Eviction of opposite parties 5 and 6.
lordship. Opposite party number 4, 5 and 6 has illegally encroached the government land.
All right. Petitioner's representation dated
Annex of 3, lordship.
Annex 3 shall be examined by the
Opposite party number 3 and 4.
3 and 4.
no, can't be. Will say Tasildar Kantabanji. And after notice to the petitioners and opposite parties 5 and 6, and after giving them a hearing, reasoned order shall be passed not later than 15th May and be communicated to the parties not later than 22nd. The court clarifies it is not expressed in email.
Item number 6.
Wait, please, Lord. Because the delay is about 45 days.
That's all right. Tell us.
Sorry, no.
Condone. Tell us.
Yes.
Tell us what the matter is.
Here the matter is that the ex-employees, those who are retired, their children were given benefit of employment. So I was empaneled. I was given intermittent appointment from 91 to 94. Now all of a sudden, without any rhyme or reason, they have terminated service. I went to the industrial tribunal.
Writ appeal is not maintainable, sir. This is against a labor award. It's
Yes.
227. No writ appeal is maintainable.
In 227, what the Honorable Secretary just did,
Sir, no writ appeal is maintainable against 227.
my lord, because the Honorable Single Judge failed to exercise jurisdiction in not referring to all the exhibits marked in the
All
court
that's
documents.
right. No writ
Here-
appeal is maintainable. It's a
Here-
full bench decision of this court, sir. You see, the impugn order was passed by the learned single judge in exercise of the jurisdiction under Article 227 of the Constitution to set aside a labor court, an award of an industrial tribunal. Good stop. In view of the decision of the full bench of this court
the
in
tribunal
Mohammed
said-
Saud, as affirmed by the Supreme Court, and again, same cause title, the present writ appeal is not maintainable
But in
and
fact,
is accordingly not entertained. This will, however, not prevent the petitioner from the appellant from seeking other appropriate remedies as may be available to the appellant in accordance.
in fact, the tribunal directed no reinstatement, take 1,50,000. The Honorable Single Judge set aside, saying that no, you have not completed 240 days in the calendar year by taking the date of termination from April. March, January to April, it will only have 90 days.
All right. Yes.
Item number 7.
None appears dismissed.
Item number 8.
Same order.
Item number 9.
Item 9 minutes, no instruction.
No instructions.
Item number 10.
None appears dismissed.
Item number 11.
No instruction.
No instructions. Dismissed.
Item number 12.
None appears dismissed.
Item number 13.
Again, same order.
Item number 14.
Non-compliance defects not removed for 3 years, 4 years now.
Yes, ma'am. And then in the meantime, the policy has changed, so this might-
Infractuous. So, counsel, the learned additional standing counsel states that the appeal is submitted due to subsequent events. The appeal has been rendered infractuous, disposed of as such.
14 and 17, my lords.
14, 17, same order.
Item 15.
My lord, delay in filing the appeal, my lord, there is 66 delay. And the order of the Honorable Single Judge on challenge. My lord, as per the facts of the writ application, the electrocution death was occurred in 2008 and deed was filed in 2012. And he has not disclosed the place of accident
All right.
in the writ petition.
Yes.
And the Honorable Single Judge said,
Only
That,
interim compensations. They're not interfering in these interim compensation matters.
at least liberty is given to us to raise our,
Yeah, that's already there.
that is not there.
All
Your
right.
lordship may kindly see.
All right. Since only an interim compensation has been awarded by the learned single judge by the impugn order for an electrocution death, leaving it open to the respondents to work out the remedies in other appropriate proceedings, the court is not inclined to interfere. It is nevertheless clarified that the impugn order will not be treated as foreclosing the defense that the appellant may have in such proceedings on merits. The appeal is accordingly not entertained and is dismissed with the above oppositions.
Item number 16,
None appears dismissed.
item number 18,
None appears dismissed.
item 19,
Same order.
item number 20,
Item 20 is not pressed.
Not pressed. Disposed.
item number 21,
Dismissed.
item 22,
Pardon, let's say 2 weeks time, maybe
Oh.
removal of defect.
2019 matter, sir. 2019 matter.
One
What is it
pass-
about?
One pass over.
All right, pass it.
Please.
item 23,
Item 23 मतलब DLR regulation, your lordship has fixed it to 24th April.
All right,
I am
same.
giving the order.
All right, same order. Same 24 also same.
My lord. 24, 25 also same.
25, 26 also.
My lord.
Ah,
No, 26, my lord, what happened, my lord, in that case, I want to withdraw because if I have filed e-filing, so it will need double number, my lord.
I see. 26 withdrawn, disposed of
And
is withdrawn.
And 27 also. was-
Disposed of is withdrawn. All right.
item 28,
28
order.
Same, no, that is same order.
That's right.
29 withdraw.
Pardon, Your Lordship, item 11, I am for the opposite party.
11 you put down his appearance.
11, sorry, my lord.
item 29,
29 withdraw.
Withdrawn.
item 30. Supplementary list, item number 30,
All right, none appears dismissed.
item number 31,
Plus item number 31, I may be allowed to withdraw with liberty to file review.
Review.
petition.
So 32 also same.
32 also.
Ah, 31, 32. Dispose of is withdrawn with liberty to file review.
item 33,
33 my DLR, that is 24.
DLR matter.
item
Regularized.
34,
34 also DLR.
All right.
35.
item number 35,
And in 35, you will also already issued notice in a similar case. Next, what day?
What's the date?
No, next day, it was listed day before yesterday.
No, what matter is this?
That is that is the matter that in similar case, the tribunal passed an order. So in that case, we filed a review. Only ground that tribunal directed to give them promotion from the date when what has happened in the meantime, those who are given ad hoc promotion, that ad hoc promotion was withdrawn.
No, but which is a similar date for this matter?
Date, my lord, I am passing over.
All right.
I am just giving.
List along with this on that date.
I am giving the number.
This is continuing till what? Item 45.
Well,
Till 45, same order.
35 to 45,
yes.
item 46,
46, I am giving. Adjourned to my 13/4/2022.
All right, same order.
item 47,
Departmental proceeding, criminal. Take to 27th March.
Ah, same, 27 March.
48,
Ma'am, that is 35 to 45, 20th August. 21st August.
item 48,
48, but you'll also fix it 23rd March, the contractual matter.
Just on 23rd.
item 49,
This is the matter regarding that job contract, and but in similar cases that in Varchar, you'll also have granted stay and it has been fixed to 14/9/2013.
14 September 2023. All right.
item 50,
50 mile rehabilitation. 30th August.
30th August.
item 51,
That is also rehabilitation.
30th August.
52 also same.
Item 52.
Same.
Item 53.
None of this is missed.
Item number 54.
That your lordship may fix it to 23rd March.
23rd
That is
March.
contractual matter.
Item 55.
That DLR matter 25th April, 24th April.
24.
I have given that number. 56 also same, 57 same.
Item 58.
50 promotion during pendency of departmental proceeding, that 27th March.
27 March.
Item 59
59 same. Ma'am.
and 60.
60 rehabilitation matter. 30th
30th August.
Item 61.
61, my lord, the promotional matter, the first day the case has been disposed of, but there is delay involved in this case, my lord. So I filed a miscase seeking condonation of delay also.
All right, notice on that and this returnable 1st May.
The in
Thus, yeah, stay till the next date. All right.
Item 62.
62 my DLR matter.
27
62,
March.
63, 64 same.
27 March,
No, my lord, 24th April.
24th April. All right.
Item 65.
My dear lordship, in this case, notice has been issued and matter has been fixed to 27th.
All
Probably
right,
it may be
27 March. All right.
One password matter. Password matter item 22.
My lord, the subject matter of the appeal is, my lord, with regard to the liability of the financier to pay road tax, my lord.
It's covered, no?
My lord,
It's not covered.
covered, my lord, the liability, so far as the finance is concerned, my lord. So till the period when it was in possession of the financier up to repossession. It is also there under section 12 of the Act, my lord. Taxation Act, Odisha Taxation Act. 1975.
All concurrent orders, concurrent findings.
Concurrent finding, my lord, that this limited question is, my lord, whether after handing over the possession, that is the mandate of the rule, section 12. As soon as we have handed over the possession, we had handed over the possession in 2010, my lord. And thereafter, our limited contention before the tax recovery officer is that let notice be issued to the auction purchaser because he has taken possession with the affidavit that he will take all liabilities, my lord.
Unless you inform the tax authorities.
We have-
get it. No. When? Soon after handing over possession, you inform. No.
No, that we have not.
Unless you inform, they have to go against.
No,
whoever is
during that tax recovery proceeding,
there's something called a registered owner. That registration happens with the transport authority.
my lord.
If you say you are no longer registered owner, unless you inform the transport authority, how will they know whom to proceed against for non-payment of tax?
But during tax recovery proceeding, they could have issued a notice to the auction
Not
purchaser.
necessary, sir. They go by the registration, whatever is with them. They can't now chase everybody, whether they're registered or not.
The registered authority, they have not proceeded against the registered owner. They are saying you are the financier, you have taken possession. So even if you have handed over the possession, you are liable. That your lordship, that with regard to that issue.
Because he did not ply the vehicle. Just read the para 11, page 11, sorry. After repossession of the vehicle, financier has to inform the registering authority about that fact and also apply for off-road. You don't do all that.
Well, off-road intimation, some requirements are there that tax clearance, fitness,
Correct.
all these documents, so far as the financier is concerned, an ordinary registered owner, he can supply all these things.
See, we can't put the burden on the transport authority to assume that despite your taking over possession, the owner will be liable.
No, I am not saying the owner is liable. We are saying the auction purchaser is liable. The
Whatever,
person was
sir,
taken
that
over-
fact has to be brought to the notice of the.
No, we have
District.
brought during proceeding, my lord, we have brought it. Is simply notice could have served the purpose, my lord.
It's all.
If had the tax recovery officer issued a notice to the auction purchaser,
All right.
that could have solved the
The
purpose. Here I have
present
submitted
appeal is-
two judgments of the your lordship. I had glance. That judgment your lordship have a glance where it was held paragraph judgment of the Uttar Pradesh on High Court, my lord, paragraph 2, my lord. Having had this paragraph 2, your lordship have a glance. Having had the Lord Council petitioner and in view of decision of so and so, we are of the opinion that even if the vehicle was not being supplied with finance company, namely petition, they are still liable to pay road tax for the period when the vehicle was in their possession. Once the
No,
vehicle
but
has been
here there's no indication whether the tax authority was informed, the transport authority is informed or not. You say the present appeal is directed against an order dated 9 July 2019, passed by the learned single judge, dismissing writ petition civil 12953 of 2016 filed by the present appellant, whereby orders dated 24th November 2015, passed by the tax recovery officer cum regional transport officer, bracket RTO, bracket Cuttack, and order dated 20th June 2016, passed by the transport commissioner, State Transport Authority, bracket STA, bracket Cuttack, were challenged. The short ground on which the appeal was preferred was that the appellant, being the financier, was not liable to pay the road tax for the period during which it had repossessed the vehicle for non-payment of the borrowed amount by the original owner, since it had in the meanwhile been sold to an auction purchaser. Paragraph. Relying on the judgment of the Allahabad High Court, dated 20th August 2015, in writ tax number 660 of 2015, bracket Shriram Transport Finance Company Limited versus State of UP, it is sought to be contended that it was incumbent on the Transport Authority, on the RTO, to have issued notice to the auction purchaser, whose details were provided during the course of the hearing by the present appellant. Paragraph. The fact remains that the appellant did not inform the RTO of the fact that after repossessing the vehicle in question, it had sold it by way of an auction. And this fact was not intimated by filing the prescribed Form H for change of ownership. Full stop. Without the Transport Authority being actually intimated in the statutory form, it was not open to the appellant to contend that the liability to pay the tax shifted to the auction purchaser. Full stop. In State Transport Finance Company, Shriram Transport Finance Company Limited versus State of UP Supra, the narration of facts by the Allahabad High Court does not reveal whether in that case the appellant did inform the Transport Authority of the change of ownership. Paragraph. Consequently, the court is unable to find any error having been committed by the learned single judge in the appeal order. There is no merit in the present appeal and it's dismissed as such.
Pardon me, Lord. I am 30. Item 30, Miller.
30. 30 we've not reached yet, no? We have. Oh, it's passed over. Yes, tell us, tell us.
Challenging the order of that regularization, basing upon which this writ application has been disposed of. This is basing upon the judgment of 19951.
Very
wherein
first day.
State also filed this writ appeal.
First day hearing.
Exactly.
All right. Notice returnable. 5th May. There should be a stay in the meanwhile. Notice both on delay and the main writ.
Well, delay is not there. Only 2 days by virtue of that COVID
All right.
period.
Delay is condoned and then main writ. All right.
Deep blue blush.
Supplementary stress admission item number 1.
You would file an affidavit. What is the matter about?
This is 24920.
WPC 24920 of
We have
2020.
filed our counter.
Ah,
The learned counsel for the petitioner is contesting for secretary.
Uh-huh.
Perhaps he is not present, that is why.
I see.
Lordship may-
All right. Counsel, the petitioner has stated to be in some personal difficulty today. List on. June, 30 June.
Item number 2.
May I please? This is an application under 11(6), Your Lordship. The
All right. Notice
arbitration-
returnable. 12th May.
This is I was the contractor who undertook a construction of 2700 square
Madam,
meter.
notice returnable 12th May.
Yes,
Ah,
Item number 3.
much obliged.
pass over.
Item number 4.
Pass over.
Item number 5.
Judgment has not yet been pronounced by the Honorable Supreme Court, even though these regarding that
It is
stamp.
stated the matter is still pending the Supreme Court. List on 7 July. Oh, no, actually, Supreme Court opens only that week, 28 July.
Counted.
All right.
Item number 6.
My lords, we've received a reply yesterday evening. I believe it might not be on record as well. But we've received a reply yesterday evening. The
All right.
respondent of yesterday.
The count of state would have been filed. We brought on record, rejoined for the next date.
My lords may say rejoinder if any, because it might not be required.
All right. 30th June.
Great.
Item number 7.
It's item 7, we have appointed our nominee arbitrator,
Ah,
and the same has been intimated to the other side as well.
who's for
Yes.
the?
Because
Ah.
I have received the
Alright.
appointment letter.
All right. It is stated that the state has nominated its arbitrator and has informed the counsel for the petitioner. In that view of the matter, the earlier directions issued will hold good. No further orders are required at this stage.
Lords, the arbitrators may be given liberty to choose their proceedings.
Yes,
where they can
nominee arbitrators will choose the
choose the
third.
venue.
Yes, will appoint the third arbitrator as required under law within a period of 1 month from today.
Yes.
The petition is disposed of. Right.
Item
No,
number
disposed of, my lords, dismissed is going against, it's creating a lot of difficulty for me. Disposed of maybe written.
I've just said disposed of.
Much of less, much of less, much of less, much of less.
Item number 8.
My lords, notice was issued in this matter, but nobody has appeared, I think.
No, has it been served?
My lords,
Served. Okay, none appears despite service notice. What's the amount?
amount 40 lakhs. my lord.
Ah. Will I have any advocate?
Your lordship,
Ah. Appoint Shri Partha Mukherjee, advocate as sole arbitrator, to adjudicate the dispute of the parties, including their claims and counterclaims. The arbitration will take place under the aegis of the arbitration center. All right.
Item number 9.
That's item number 9 also, we have appointed our nominee arbitrator.
Hmm.
That was appointed 2 days back, so.
Ah,
that's-
We have received the letters. Lords,
ah,
that can be-
same order as that earlier one. All right.
Yes.
All right.
with-
Pastor matter, item number 3.
None appears despite a passover. Dismissed for non-prosecution.
Item number 4.
None appears despite a passover. In the interest of justice, list on 5th May, defect be cured in the meanwhile.
Specialist stress admission item number 1.
May I please, your lordship? Here in this case, my lord, the petitioner is the central government. My lord, he has filed a petition for transfer of the case to BSF court, my lord, as per section 80 of the BSF Act, my lord. And that application was allowed by the magistrate, my lord. The lordship, that is annexure 1, my lord. Thereafter, my lord, the learned additional district judge initiated a show moot proceeding, my lord, and thereafter they has rejected that order passed by the magistrate, my lord. And your lordships may kindly glance section 80 of the BSF Act, my lord. My place, my section 8 says choice between criminal court and security force court. When a criminal court and a security force court have each jurisdiction in respect of an offence, it shall be in the discretion of the Director General or the Inspector General of Deputy Inspector General, within whose command the accused person is serving, or such other person as may be prescribed, to decide before which court the proceedings shall be instituted. And if that officer decides that they shall be instituted before a security force court, to direct that the accused person shall be detained in force custody. Then, my lord, 81.
No, but he was under training, is it, the driver?
He is a driver, my lord.
No. Was he under training or is he permanently appointed in the VSF?
Not a training. As per the order, my lord, he is not a training, my lord.
No, just come to para 12.
Para 12 was petition, my lord.
No. Impugned order, sir. Page 36.
Sorry.
Page 36.
My lord, having gone through the aforesaid provision, it is seen that the BSF authority, although stated that at the time of the incident, the accused driver was on active duty, but no such document has been shown to substantiate their stand.
Yes.
Moreover, the offender is either a young person nor undergoing training, and the offence is not a serious one. That apart, no such material has been placed before the court to show that the trial of the offender by a criminal court will.
So he's not under training at all.
My lord,
it says there's nothing to show it will affect his training. So you're saying he was not a trainee.
Training, my lord. He is saying training will affect, no document is produced that he was effective training, my lord. And he is, as per the, my lord, the petition, my lord, he was appointed as driver, my lord, and he was on the day of occurrence, he was moving.
But you did not produce any material to show that he was appointed as driver. No document has been shown to substantiate the stand that the accused driver is on active duty.
But once, my lord, you lordship say, if the DIG, my lord, is the best person to decide whether the matter will be.
What about the, you have not implemented the actual informants?
I have to amount bits, my lord. Informant is necessary. I have to amount bits.
Counsel, the petitioner seeks leave, she seeks an adjournment to file a proper application to implement the informants. Interim order to continue, list before the roster bench on 26th April.
Obliged.
Specialist item.
Steps be taken with the petitioner in the meanwhile. Right.
Specialist item number 2.
My lord, I have no instruction, my lord.
No instruction.
No instruction.
Order dismissed.
Item number 3.
None appears dismissed. Interim order vacated.
Item number 4.
None appears dismissed.
Specialist item number 5.
None appears dismissed. Interim order vacated.
Item number 6.
6, my lord, become infractious.
Infractions dismissed. Interim order vacated.
Item number 7.
Item 7, may I please, your lordships. Your lordships, challenging the order of cognizance, it's a case under section 138 of the NI Act. My lords, my only ground is that no legal notice has been issued to the
It's all right. Permitting the petitioner to raise all
Well-
pleas at the appropriate stage.
item 8 also 7, your lordship.
Same order. Right.
Item number 9.
None appears dismissed.
Item number 10.
Same order.
Item 11.
May it please your lordship, I may be permitted to withdraw and
Permitted to raise all pleas at the appropriate stage.
my lord's liberty may be granted.
Yes, yes.
My lords, because there is a the other accused case is for judgment in Justice A.K. Patnaik, my lord. So,
It's all right, sir.
in view of that, we may approach this honorable court again.
That whatever remedies you have, sir. Right.
Publish.
Specialist item 12.
May be lordship. Order of cognizance under Annex 2 Miller, as well as the proceeding is under challenge on the ground of compromise. That compromise petition has also been filed. My learned friend is also appearing on behalf of the informant.
All right. Counsel appealing for the informant refers to the affidavit filed, which states that the parties have settled the disputes and have entered into a compromise. In that view of the matter, take from the prayer clause and all proceedings pending pursuant thereto are hereby quashed. Including the order dated 4 June 2018 of the SDGM bracket S Baripada in GR number 1003 of 2017, taking cognizance of the evidence. All right.
Item number 13.
None appears dismissed.
Item number 14.
Same order.
Item number 15.
Infractuous dismissed.
Item 16.
My lord, the matter has become infructuous.
Infractuous dismissed.
Item number 17.
None appears dismissed.
17 both the way. Item number 18.
None appears dismissed.
Item number 19.
None appears dismissed.
Item number 20.
Same order.
Specialist item 21.
Compromise. This is a compromise case.
Where's the affidavit? There's no affidavit, sir.
Affidavit.
Permitting the petition.
Annex 2, page number 15.
That's the marriage certificate.
Sorry, Annex 3, page number 18. Affidavit.
These are all before. You have to file a proper affidavit, sir. There's an affidavit soon after that. But this is not. No, you just will say permit. You can file all this before the trial court, sir. Permitting the petitioner to urge all the pleas raised in the present petition for the trial court at the appropriate stage. The petition is disposed of.
Item number 22.
The cognizance order is on a challenge. But in fact, they have, in the meantime, there is a compromise. I'll file all the application before the learned trial court.
All right. Counsel, the petitioner seeks leave to withdraw the present petition, liberty to approach the trial court in order to place papers to show there's a compromise between the parties. Disposed of his withdrawal, the liberty is straightforward.
Item number 23.
None appears dismissed.
24.
May I please. Challenging the order of cognizance, my lord, on the ground that, my lord, this case is not maintainable. The lordship has the complainant, opposite party number 2, has issued a check.
Not found, it's come back. So 138 or 420?
Well, 130-day. I have filed an application on section 130-day.
The respondent not found, sir. So when the matter is listed, nobody will appear to get closed. This person is not found, the complainant. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed. Correct.
Item number 25.
None appears disposed.
Item number 26.
That appears dismissed.
Item 27. May it please, my lord.
Lordship, here is in a case wherein the petitioner is the owner of a sawmill. A raid was conducted by the opposite parties number 2 to 8, your lordship. All of them are public servants. Thereafter, a final report was filed on the FIR of the petitioner stating that the accused persons who are public servants conducted the raid with the following due procedure of law. Thereafter, a protest petition was filed by the present petitioner, based on which cognizance was taken by the magistrate. The relevant order which I have challenged is at page 33, your lordship. May kindly see. Peculiar order, your lordship. 10 lines from the bottom. May I place?
Yes.
Hence, as the present accused persons had been to the spot of incident in their official capacity, and as there exists a reasonable connection between some of the alleged acts of the accused persons and the official duty of the accused persons, therefore, there is a need of prior sanction of the government as contemplated under section 197 CRPC to proceed further in this case. It appears that the protest petitioner has not obtained any prior sanction from the competent authority to prosecute the accused.
Why should
Exactly, your lordship. Private party is. Hence, the protest petitioner is directed to obtain sanction from the
proof of delivery of notice not yet back from opposite party number 3. Opposite party number 3 is the main contesting rest.
Lordship.
But 4 and 5, 4 to 8, what happened? Served.
This way. So.
Although opposite parties 4 to 8 have been served and none appears on their behalf, notice to opposite party number 3 has been returned. No. What about tracking reports not there? There is no proof of delivery of notice to opposite party number 3. Fresh notice to opposite party number 3 returnable for the roster bench on 4th May.
Great.
Item number 28. I'm appearing to the opposite party number 2.
Okay, none appears to the petitioner. Dismissed for non-prosecution.
Item number 29.
None appears dismissed.
Item number 30.
Same order.
Item 31.
Same order.
Item number 32.
Infractions dismissed.
Item number 33.
Infractions. All right.
Item number 34.
Item 34 is a police officer. Some of the mailers, local bar members and conniving with others filed a complaint case mailers. The complaint case mailers are there.
Requisites not filed for notice, sir.
Requisites, may I submit one thing? Here in this case, mailers may be permitted because then mailers there are a lot of strike and all these things. I was not allowed to appear there.
Now you appear.
No, that
now it's all very peaceful, sir.
No, it's peaceful. It's peaceful, but they are not cooperating to participate through it. But I may be permitted so as to get that certified copy of the cognizance to challenge it. That I think that would suffice the purpose because complaint case a police officer is being harassed. Local people, the bar is not supporting, even they are not allowing others to participate.
This is 5 years ago. Which bar is this?
No, so this is Jaipatna. Matters. Fact is, they are not cooperating, they are coming forward. I sent somebody, requested somebody to go and appear there. There also he was subjected to register. Then matters. Now thing is that matters, I cannot place before matters about the cognizance order because I could not get that certified copy also.
You say the grievance made by Mr. Dayananda Mahapatra and counsel the petitioner is that due to non-cooperation of the local bar, the petitioner is unable to obtain a certified copy of the order passed by the JMFC, taking cognizance of the offence. Paragraph will be open to the petitioner to approach the said court for issuance of a certified copy in accordance with law on the strength of the present order. Thereafter, it will be open to the petitioner to seek appropriate remedies in accordance.
So,
petition is disposed.
I love it.
Item number 35.
None appears dismissed.
36.
Same order.
Item number 37.
Same order.
Item number 38.
May it please your lordship, the present petitioner has filed his application on basis of amicable settlement, my lords. The facts of the case is where the petitioner had taken a sum of around 20 lakhs for in lieu of selling his land, which he did not sell to the complainant, due to which the complainant registered a FIR. During the pendency of the case, the sister of the present petitioner paid an amount of 4 lakhs for amicable settlement, and
No,
the
but
rest.
this affidavit is only to agree to release an interim bail.
Yes, Lord, sir.
That's not the affidavit for settling the matter, sir.
Right, so we'll need to take instructions.
No. Permitting the petitioner to raise all pleas at the appropriate stage. The petitioner.
Obliged, Lord, sir.
All right.
Item number 39,
None appears dismissed.
item number 40,
None appears dismissed.
41,
No instruction, my lord.
No instructions dismissed.
item 42,
Memo taken on record. No instructions dismissed.
item number 43,
None appears dismissed.
item 44,
During discussion, my lord, that because of the late filing of the requisite notice could not be served on OP number 2, my lord. That notice was filed on 1/10/2019, my lord. The order was 23/9/19 as reflected in the first title. So let the notice be issued to the OP number 2, my lord, who is the private party to that extent, my lord. Only 7 days delay is there, perhaps, I think, from the date the order was passed on 23/9. Then thereafter requisite filed on 1/10/2019, my lord. Only 4 to 5 days delay, I think.
No requisites filed, sir.
Yes, my lord, this is the slip, my lord, with me, my lord.
When did you file it?
On 1/10/2019, requisites filed for opinion opposite party. May kindly see that the slip I am giving.
Counsel, the petitioner produces a slip.
Yes, my lord. Late filing, I am saying, my lord. That was also mentioned in the cause title, my lord. For which it
Counsel, the petitioner produces a slip to show that requisites were filed on 1st October
much obliged.
2019, which is within a week of notice being issued. Although the order required it to be filed within 3 days, considering that the delay is not substantial, another opportunity is granted, a fresh opportunity is granted to the petitioner. Issue notice returnable before the roster bench on 11th May. Tracking report by speed post with registered, the requisites be filed within 1 week from today.
Requisites already filed, my lord. Requisites already filed, my lord.
All right, the requisites already filed now be utilized, but you'll have to file it for registered speed post, sir.
Sorry, registered speed post I have filed.
Acha.
Everything has
requisites already filed to be utilized for that purpose.
Much obliged.
Tracking report will be placed in record, interim orders to continue.
Much obliged.
item 45,
Item 45 on behalf of Mr. H.N. Mahapatra, we kindly acceptance of requisite, my lord. Acceptance of requisite, my lord.
What did you say?
Acceptance of requisite, my lord.
Acceptance of requisites.
Acceptance of requisites. Oh. All right. The what is the matter about? Tell us.
Sorry, madam, file is misplaced, madam. File is misplaced, madam.
Then you say counsel for the petitioner states the file has been misplaced, dismissed non-prosecution with liberty to the petitioner to revive it as and when the file is placed.
item 46,
Sorry, my lord, I am not able to test out my file. One more time, I will left you.
Same order. Whenever you file it, you file a restoration application. Right.
item 47,
None appears dismissed.
item number 48,
None appears dismissed. Memo taken on record. No instructions dismissed. Same.
item number 50,
None appears dismissed.
item 51,
None appears dismissed.
item number 52,
Lord, item 52, the matter is already closed, my lord.
All right, infraction is disposed of.
Item 53.
May I please, your lordship? Yeah, the matter has been comprised between the petitioner and the victim, my lord. That is why I filed the application for.
All right. The IA is taken on record. The counsel appearing for the complainant confirms that the matter has been settled between the parties. The affidavit of respondent 2 is also on record. In that view of the matter, take from the prayer clause and all proceedings consequent thereto are hereby quashed.
Obliged, sirs.
Item number 54.
None appears dismissed.
Item number 55.
My lord, I am open for the respondent.
For the respondent,
Yes.
none appears for the petitioner, dismissed for non-prosecution.
Item number 56.
56 lawsuit matter has been settled between both the party, husband and wife, in a matrimonial dispute by way of taking the permanent alimony. The joint affidavit has been filed both the parties.
Where is that?
Lordship.
Where is the joint affidavit?
Joint affidavit filed lordship on dated 4/7/2022. I have the copy and no slip lordship. Jointly filed both the parties.
1 minute, let me just see where it is.
Copy check. Copy date. Sorry, I have the copy lordship. May I give lordship?
Just take it out from our file.
Again,
Give him the-
yeah. The copy is not in the brief lordship, but I have the copy and slip lordship.
You file it in the registry. You say, counsel, the petitioner states that he will be filing within 2 days the affidavit of the opposite
In
party
course of the
complainant.
lordship, I'll file.
All right, because the affidavit of the opposite party complainant confirming that the matter has been compromised between the parties, list before the roster bench on 10th April.
Item number 57.
None appears dismissed.
Item number 58.
Whereas I'll take leave to file an additional affidavit because the petitioner has undergone CIRP process and this is prior to the process. So therefore, my lords, I have to file the resolution plan, the
Mr.
order.
Rai, learned senior counsel, the petitioner states that an additional affidavit will be filed within 2 weeks.
Within a week, my
Within a
lords.
week, interim order to continue, list before the roster bench on 17th April.
Item number 59.
None appears dismissed. Both matters.
Both. Item number 60.
Interim order. None appears. Interim order.
Item 61.
Save order.
Item 62.
May I please, Lordship, I am from the VC for the petitioner.
Yes, yes.
My lord, here I have challenged the cognizance that is taken under section 420 and other offences, my lord, on 2 grounds. That the offences to where the cognizance are taken, the necessary ingredients are not fulfilled. And my second ground is that the court that has taken cognizance has no jurisdiction to take cognizance. My lordship, I have a glance to page 9, where in the complainant averred that all the cause of action has arisen in Koraput, whereas the court has the JMFC Lakshmipur has taken cognizance in all the offences, my lord. This court has no territorial jurisdiction, my lord.
Where is Lakhimpur?
My lord, at the time of...
No, where is Lakhimpur? Which district?
That is under Koraput district, but is that not? That is under Koraput district. But it should have been before the SDGM Koraput, my lord.
No big deal, sir. All this is not a big deal. Yes.
these are the two
Take all
grounds, my
pleas at
lord.
the appropriate stage. You said permitting the petitioner to raise all pleas at the appropriate stage in the trial court. The petitioner is disposed of. Interim order vacated. Right.
Item number 63.
63, my lord, here I am also for the petitioner, my lord. The order of taking cognizance I have challenged. But my lord, charge sheet was submitted under section 493 and other offences, my lord. But cognizance was taken under section 494 and other offences, my lord. 494 cognizance should not be on the basis of police report, my lord. It should be on the complaint. That is the ground, my lord. Page 48 is the impugned order.
But it's combined with several other offences.
It is there, my lord, but there is no allegation of 494. It is the allegation.
Same order, permitting the petitioner to urge all pleas at the appropriate stage. Interim order vacated. All right.
Item number 64.
May I please, Lord's Mayor? Well, I have challenged the order of cognizance and the proceeding filed by the court below regarding the offence on 138 CSB, NI Act, my lord. But in meantime, I have already paid the all amount, my lord, as per unnecessary 4 series. I have already paid, my lord. That is a 2 charge. It is one is 3 lakh and another is 3 lakhs.
Unless the bank files an affidavit, can't be closed.
My lord, already filed. My lord, already I have to cite.
Unless the bank, this is what the complaint is a bank, right? Or private party.
Private party.
Unless you file an affidavit.
I have a decision, my lord.
Decision won't help, sir. What are the affidavit of the private party confirming that all the entire money amount has been paid?
Already, therefore, direction was given, but it is not filed. Affidavit will not appear in this stage. I filed fresh notice, my lord. I already. My lord, 6 lakhs amount is due, my lord. I have already paid, my lord. That is the already
permitting the petitioner to raise all pleas at the appropriate stage in the trial court. The petition is disposed.
File a discharge.
Order vacated.
File a discharge. But as per the managing director is a party, my lord. As per the Supreme Court,
point out to the trial court all that.
As per the decision of the Supreme Court, he has not the case is not maintainable, my lord. That is the decision of the.
It's all right to raise the plea there, sir. Right.
Item 65.
Regarding the maintainable.
Everything, sir. All pleas you can raise there. Right.
Item number 65.
None of this.
Item number 66.
May I please, your lordship? My lordship, I may be permitted to withdraw
All
the
right.
liberty to raise all contention.
Permitting, yes, permitting to raise all.
Obliged, madam.
Item number 67.
Dismissed as withdrawn.
Item 68.
In case of a commercial transaction, alleged offense is the 406 and 420 and 50. I have given a note, my for your lordship. Petitioner is the director of the company, and the mere absence of the any provision is not vicariously liable as far as 2008 Supreme Court answer. As far as the 420 is concerned, dishonesty, intention.
No, this is not 138, sir. This is 420.
So he has filed a complaint person. Instead of filing 138, he has filed a complaint case, my lord.
Correct.
This is honest intention at the beginning and the subsequent conduct.
Ultimately, it's about money, sir. What was the amount?
And the nature of mis.
What is the amount that you have not repaid?
35,000.
35 lakhs, 20 lakhs.
35 lakhs.
How much lakhs are you paying him?
I have issued check of 32 lakhs.
How much lakhs are you prepared to pay? That will only decide. Nothing else will decide.
That I will take instruction.
You take it at your time. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of. Interim order vacated. All right.
Item number 69.
Item 69, lordship, no instruction.
No instructions dismissed.
Item number 70.
Permitted to withdraw, my lord.
Dismissed as withdrawn.
Item number 71.
May I please, George? I am in DC matter. Yes. File this application to quash the entire proceeding in view of compromise between the parties, my lord. Annex up to page 16 may kindly see. The bank has issued the letter, my lord. We have to advise that the caption loan amount, Mr. Suraj Kumar Sahu, has been closed on the receipt of amount as per the compromise settlement. It is approved by the bank.
What do you
16, ma'am.
All right. The bank has issued a certificate saying that the outstanding amount has already been paid. And there's also no due certificate issued by the SBI. In that view of the matter, the proceedings in Lakshmanagar PS case number so and so, and all proceedings consequent thereto. Take from the prayer clause. I hereby quash. All right.
Item 72.
I am for the opinion.
None appeals for the petitioner. Discussion not possible.
Item number 73.
May I please? The petitioner number 1 is the mother-in-law and petitioner number 2 is the sister-in-law of the informant, who is the opposite part number 2 here. So there is omnibus allegation made in the FIR as well as the 161 statement. And it is the settled law, your lordship, that on account of omnibus allegation, the relative of the husband should not be prosecuted, your lordship.
Not at this stage. It's permitting the petitioners to raise all please.
Your lordship, grant me one indulgence, your lordship. The FIR and the 161 statements are in ODI, your lordship. Your lordship, grant me one opportunity so that I can translate.
Not necessary.
Your lordship, otherwise there'll be prejudice, there'll be.
Nothing at all, madam. Nothing at all.
It is the constant view of the Supreme Court that they should not be harassed on
this can't be decided here at this stage. Some evidence will have to be led.
So, your lordship,
The petitioner raise all please.
Lordship, there are judgments like.
Yes, there are plenty. There are plenty. The stay orders vacated. Right.
Item 74.
That the present petitioner and the informant is the husband and wife, my lord. Due to a silly mistake, the informant filed this FIR against her husband, my lord. And the 164 statement is there, man, page number 13 and 14. She admitted in his 164 statement, the informant clearly says that she was married to the petition number 2.
That has to be tested, sir. That has to be tested.
Yes, ma'am. The compromise, the informant filed the affidavit, my lord.
What is the offense?
Offense, POXO. POXO is also husband and wife, my lord.
Go for the trial. So permitting the petitioner to raise all pleas at the appropriate stage. The petition is supposed to. Is there an interim order?
Yes, ma'am.
Vacated.
Item number 75.
None appears dismissed. Interim order vacated.
Item number 76.
May I be lordship. This is an application for quashment of the entire criminal proceeding order of taking cognizance. The fact of the case is like that. The present petitioner is implicated as the accused in the subsequent charge sheet filed by the police, your lordship. The main accused who has faced the trial has already been acquitted by the London Trial Court. I have given the judgment, that is page 82.
You can show that
Yes,
trial court same judgment and you get out, sir.
May I permitted to submit a factual case, your lordship. The charge sheet is subsequently filed by the police. The charge sheet witness all are the same. All are the same. They have already examined by the London Trial Court. They have never ever whispered the name of the present petitioner, lordship. That's fine. And during is the already competent court has acquitted the main accused who has faced the trial. And so now
2, sir. 302, 201. You must have absconded.
No, lordship, never. I have not ever absconded, your lordship. I am in bail, lordship, and anticipatory bail, your lordship.
Anticipatory bail,
yes,
not 2.
Yes, your lordship. What happened? The name of the petitioner
302, you got anticipatory.
I have given certificate, lordship. I have already stayed. I have heard in my petition, lordship. I have been bailed by the ABLP by this honorable court, your lordship. My name never appeared in the FIR, lordship. In subsequent charge sheet filed by the police, my name is appeared. Thereafter, I approached before the honorable court. Honorable court granted in bail. And
bail or anticipatory bail?
Anticipatory bail. I mean, lordship, I surrender and go bail, lordship. But I've given by this honorable court, lordship. My respect, submission, lordship. All of the charge notices are same, and the same never ever taken the name of the present petitioner. And now if the present petitioner faced the trial court, the trial court is not allowed the abuse process of law, lordship.
Abuse of process.
And sticks.
Who's talking about abuse of process?
Kindly glance to page 82 by the judgment part of the trial court. The witness, those who are initially filed by charge sheet, the witness, those are witness already been examined, and subsequent charge sheet filed by the police is the same witness are in the list, your lordship.
All right. Permitting the petitioners to raise all pleas at the appropriate stage. The interim order is vacated. The petition is disposed of. All right.
Lordship, liberty to raise and takes London Trial Court shall take the.
Just do the favor of appearing there. You've enjoyed your liberty for too long now. Yes.
Item number 77.
The order taking cognizance is under challenge, my lord. My specific case is that the informant who lodged the affair, he has not been examined, and other relevant witnesses, those who are the party to the my lord dispute, they have also not been examined, and the charge sheet has been filed, and order taking cognizance has been taken by the my lord and magistrate.
So, all right, sir. Permitting the petitioner to raise all pleas at the appropriate stage. The interim order is vacated. All right.
Item 78.
None appears. Interim order vacated.
Item number 79.
79 for, if I may please your lordships, my lord. My lord, the order, there are three things under challenge: the FIR, the charge sheet, and the order of cognizance. My lord, at present, I would be limiting my prayer only to the order of cognizance. So far as it concerns, my lord, the other two, it would have become infructuous. My lord, the case is this, that sanction was sought for against the public servant. Page 29, your lordship may kindly see. Sanction has been refused. Page 29 of the brief. This is the charge sheet, last two paragraphs. Sanction for prosecution of accused Sri Sailendra Kumar Samal, who is the present petitioner in this case, under section 19 of the PC Act, has been refused by the competent authority, communicated by letter dated this. Finding prima facie case, a competent authority has moved to accord sanction for prosecution, but it was refused.
You've not, who's the informant? The Vigilance Department itself.
Your lordship.
It's a trap case.
No, my lord. My lord, what the allegation is this, that in 2011, certain plots of lands were registered. I was the district sub-registrar then. In 2013, they get some vague allegations that some of these lands have been registered. And then after an inquiry is conducted.
Okay, you appear for the vigilance. So when sanction is refused,
sanction was refused in respect of 19. Other offences, IPC offences.
197, they have
420, 468. 420B, 471 is also there. IPC offences sanction is not required. Those offences.
My lord,
the law, settled law of the.
I'm sorry, my lord. My lord, may I just rely on some decisions? No, my lord. My lord, 197 sanction is mandatory. Probably 19, my lord, after he's retired is not required. But so far as it concerns 420 and the other.
By now he's retired.
My lord, by now he's retired, but my lord, he's been suspended. My lord, this case has to go because of those, my lord, he's now not getting his pension and other things. This case cannot stand, my lord. On the face of the record, sanction refused, cognizance taken. On, my lord, and then judgments, my lord, 197 mandatory. Your lordship may kindly have a glance. My lord, may kindly have page 742 without troubling your lordship for the entirety. The last page of the judgment.
All right. You say counsel the petitioner insists that cognizance could not have been taken without sanction for prosecuting the petitioner, who was at the relevant time a government servant to cover. Not just for the offences under section 13 bracket 1 bracket C, is it, of the Prevention of Corruption Act 1988, but for also IPC offences. He relies on the judgment in Surendrajit Singh Maan versus State of Punjab, 2016 ATCC 722. Counsel appearing for the Justice Department states that he'll examine the judgment and address arguments.
As far as the judgment is concerned, the recent judgment of the Honorable Apex Court is a 3-judgment judgment. Honorable has very clearly mentioned that in respect of that.
This is all the 3 judges. Which judgment are you referring to?
I am referring to the Satyavrata Gupta versus State of Jharkhand.
Show me. Counsel for the Vigilance Department, on the other hand,
a bunch of judgments are there. I'm there. If a lordship will permit, I will hand over.
Refers to,
my lord, may I rely on some other decisions as well?
A bench of the larger bench of the Supreme Court. A 3-judge bench of the Supreme Court in Satyavrat Gupta versus State of Jharkhand, 2020 79 OCR bracket SC 728. Paragraph. Both parties will file their respective notes of submissions. List for hearing. On 5th July 2023 for the roster bench, interim order to continue.
I'm grateful, your lordship.
Item number 80.
None appears.
Item 81.
Petitioners are father-in-law, mother-in-law, and sister-in-law. Cognizance order has been challenged, Lords. Cognizance has been taken under section 498, 506, and 30. Your Lordship may kindly see. This matter arose out of a matrimonial proceeding, Lord. In the meantime, decree of
mutual consent.
Yes, mediated consent. It has been decree of divorce has been confirmed by this under. Your Lordship may kindly see para 8 and para 11 of the order. I paid rupees 50 lakhs towards permanent alimony.
All right. It appears that by the judgment dated 3rd August 2022, in MATA 97 to 99 of 2019, the dissolution of the marriage between the husband and wife has been given a seal of approval by this court. Full stop. This is not disputed. A copy of the judgment will be placed on record. The above fact is not disputed by counsel of the state. In that view of the matter, just take from the prayer clause and all proceedings consequent thereto are hereby quashed. All right.
Item 82.
My lord, item 82 permitted to withdraw with liberty to raise all the point at the time.
Permitting.
Correct.
Item number 83.
Your lordship, stress some time, your lordship. I will file deposition copy of witnesses, your lordship.
It's all right. What's the matter about?
Petitioner challenging the cognizance order, your lordship. Offense under section 498 or 323 506.
Same, madam. Unless it's all compromised, we can't do anything about it.
Your lordship, due to after death of her husband, the wife also sister some also dispute create, your lordship. Thereafter, the case has been registered against the in-laws, your lordship.
All right. What are the three petitioners or what?
Your lordship, already in this case, already notice has been issued, but nobody has appeared. No, stress out the address of the opposite party, your lordship.
That's the problem, madam.
Your lordship, in this case, I already paper publication has been.
No, in these kind of matters, paper publication will not help. It will have to go to the trial court.
Against BW.
That's right. All the four petitioners are around?
Your lordship, huh?
No. The first petitioner was 78 years when he filed.
Your lordship.
All right. You say the four petitioners will appear before the trial court on 24th April 2023. Thereafter, their applications for exemption appearance will be considered in accordance with law by the trial court. No further directions are called for. The petitioners are permitted to raise all pleas at the appropriate stage of the trial court. The interim order is vacated. The petitioners.
Item number 84.
None appears dismissed.
Item number 85.
Item 85. Quashing of FIR under annexure 1, page 14 to 20. And also the allegation is that both the petitioner availed 1 crore 4 lakhs term loan along with the cash credit loan for the installation of a cold storage lordship. And due to non-payment of these amounts, they have a 420 lordship. And also they have the lost 2 FIRs lordship under annexure 1 and under annexure 2 lordship. The self-same allegation lordship. And also they have filed a dispute case lordship. And that has been awarded lordship. Kindly see page 10, para 15 lordship.
What has happened? Trial is going on or not?
Yes, lordship. Trial is going, and also
investigation is going on. Crores of rupees has been misappropriated, adopting fraud. And he has also tampered the document, mortgage document.
All right. 468, 471.
409 and 131 CD, 409 and 120B. Along with 468, 472 and other offenses.
Lordship, under annexure 2 is the FIR was lodged in 2015 and self-same allegation of.
It's all right. Probably the petitioner to raise all pleas to the appropriate.
They have not filed a final form yet, lordship.
It's all right. The interim order is vacated.
Item number 86.
My pleasure, lordship. The petitioner challenges the order under annexure 5 mailer at page 21. The petitioner, in favor of the petitioner, work order has been issued. Work has been completed. But his payment has not been sanctioned, for which he sought for an RTI application to the reasons as to why the payment has not been released. But on RTI application, it came to the light that out of 5 lakhs, 3 lakh 20,073 rupees had already been released, madam. And Further, it was ascertained that the forging the signature of the petitioner, that amount was withdrawn at the instance of the OP number 2, 3, and 4, my lord. Therefore, he filed a complaint petition.
I know.
And
Allegations are of forgery, sir.
my lord, yes, my lord.
468, 471.
Cognizance was taken, but subsequently the land court below would recall that order,
Oh, I see.
my lord, which is under challenge, my lord. That
You are the complainant.
yes, my lord. I am the complainant before the land
Have you
court.
served the other side?
Yes, my lord. Notice was issued, my lord. They have.
I am
already-
40 of the madam.
What do you say?
I have no, your may pass any order, madam. I have no instruction, madam.
No instructions, all right.
Okay, not.
Counsel for the opposite party states that he has no instructions. In the present case, the challenge is to an order dated 28th March 2018, passed by the SDJM Gunapur in ICC number 30 of 2017, recalling an earlier order passed by it, taking cognizance. Full stop. As pointed out by the learned counsel of the petitioner, the impugned order is clearly without jurisdiction, as there was no occasion whatsoever for the SDJM to recall an earlier order, purportedly in exercise of a single court's review jurisdiction and court which the criminal court certainly did not have. Unquote. For that reason, the impugned order is hereby set aside and the matters ICC number 30 of 2017 is restored to the file of the SDJM Gunapur from the stage at which it was when the order taking cognizance had been passed. The learned trial court will now proceed in accordance with law.
Kindly target the matter.
The petition is now disposed of.
Kindly target within certain period that will.
It's all right. It will be open to the parties to request the trial court for expeditious disposal of the matter.
Item
number 87.
Minutes, item 87, minutes. I am the owner of the vehicle implicated under section 6 and 7 of the EC Act. While minutes, the driver carrying the vehicle minutes petrol there, allegation of addition of kerosene, blue kerosene. That is what minutes the driver has committed that mistake. At no point of time I was aware of all these facts. But subsequently, minutes complaint case has been filed. Minutes,
You can point that out, sir.
Minutes,
you can point that out in the trial.
yes, I will point out that. But only thing is that well, I didn't know all these things has happened and NBW has been issued against me.
Or the petitioner will appear before the trial court on 1st May
Minutes,
and thereafter seek exemption from appearance by filing an appropriate application.
minutes.
The trial court will independently decide it in accordance with law. Such application in accordance with law. No further directions are called for at this stage. The petitioner is permitted to raise all pleas at the appropriate stage in the trial court.
Minutes.
The petition is disposed of.
Item 88.
Modified.
88, my lord, I will raise all the point at the
All
time
right.
of hearing of judge.
All right, permitting the petitioner to raise all this. Right.
Item number 89.
Lordship, I humbly pray for 1 week time, my lord. But this, the case has been transferred, the brief has been transferred. I humbly pray for.
Is it 130?
No, transferred to you or transferred to somebody else?
Transferred to me.
Counsel, the petitioner states is recently entered appearance.
Is it 130 enactment, my lord? This,
No settlement.
no, sir. They have not tried.
Then
One short date.
that for what will happen?
With a,
What's the check amount?
1,90,000.
This you cannot pay. How many days of stay you've got since 2018?
Within the 18 minutes.
This is luxury, sir. You can't pay 2 lakhs in 5 years.
I humbly pray, let it come next week.
No. What are your instructions? Will you pay? Will you make payment or not?
Not,
If you will not make payment, then permit you to raise all pleas, sir. Is it permitting the petitioner to raise all pleas at the appropriate stage? The interim order is vacated. Yes.
Item number 90.
May I please, your lordship. One is challenging the initiation of complaint case after filing of the suit for the self allegation mills. I have filed this. Your lordship may see the plain millers. Petitioner and OP number 1 are brother and sisters millers. Your lordship just have a glance to genealogy millers as running page 29 millers.
What is it? 420? What is the offense?
After they said that by managing with the consolidation officials, I managed to record my name in the.
So 420.
But my sister, your lordship, see my sisters.
This is the most hard-fought matter, sir.
The suit is pending, my lord.
This is the whole problem.
Your lordship may come to page.
The closer your relationship, the more bitter the fight.
Your lordship has come to page 32, my lords.
Younger sister or elder sister?
you have three other sisters, my lord, they are supporting me, my lords. They filed the written statement, my lords. Your lordship may see, they say that my father gifted the property to me, my lords. Your lordship may come to, for a moment, come to page 38, my lords.
Only way it will get resolved is if you pay your younger sister some money. She obviously feels left out.
No, no, other three sisters, they say, my lords, that the father has gifted the property to me. Your lordship, just a moment, your lordship may come to page 38, my lords.
Yes.
That the real fact of the case is that the three other sisters, they jointly filed, defendant number 2 to 4, they filed the written statement, my lord.
Who's appearing with the sister?
Here, actually, he doesn't come to picture. It is an order under 156(3).
Not initiation means
just
one minute. There's a suit pending. Why are you?
My lord, question is, it has gone to the police for investigation. He doesn't
The whole
come.
problem is it's gone to the police. It's a purely civil matter, sir.
So the two distance of the appeals court,
My
my lords,
humble submission, he doesn't come to picture at this stage because neither charge sheet has been filed.
You are twisting his arm, sir, clearly.
Yes.
You're really twisting his arm. What's the possibility of settlement? You go for mediation. The contestants, the parties are actually real brothers. You say the complainant is the real sister of the
present
petitioner. The court is of the view that with there already being a civil suit concerning the dispute between the parties, there's a real possibility of settlement if a sincere effort is made at mediation. The court accordingly directs the parties to appear in the mediation center, High Court Mediation Center, on 12th April at 3:30 p.m. The report of mediation will be placed before the court on the next. 23rd June.
Interim order
to continue.
I will be particular mention, my lord, to some medical of this, I did not appear in time in item number 75, my lord. Item number 75, my lord, I am appearing on behalf of Mr. S.R. Mulia. In the meantime, the FIR has been quashed, my lord. So, CRL number 33 of 2022, my lord.
So, you're withdrawing this? Yeah, withdraw this there.
Only direction is need to the locker of the prisoners need to be allowed to operate.
What's the prayer in the present petition?
I am telling the district judge order, my lord. District judge in the section 457, under section 457, allowed the opposite party number 4 to opposite party number 3 to take over some jewelries. And
you'll have to notice. What about the other side? Have they been served?
Yes, my lord. They have already.
No. Just see.
Sorry, my lord. Actually, I am appearing on behalf of Mr. Mulia, my lord.
Somebody must be appearing on their behalf.
Already affair has been quashed, my lord.
Who's appearing? You said none appears on behalf of the opposite parties, although counsel the petitioner states that the original FIR itself stands quashed by the order dated?
Order dated 7/9/2022.
Passed with this court in CRLMC 333 of 2022. List this matter before the same judge, Justice R.K. Patnaik, on 5th May of 2023. Registry will inform the counsel to the opposite parties to remain present on the next date. Memo on record dismisses withdrawal 55.
nomination has been rejected on the ground that he was an office bearer on the date of publication of the notice.
Anyway, once the election process starts, you can't interfere.
My lords, I seek no interference, my lords. I only seek a direction in case I can justify my case, saying that his name should be published, my lords. And today is the last day at 5 o'clock. They're going to publish the notification.
You know, you read Punduswamy, NP Punduswamy, returning officer Namakkal. You read the judgment. You must. The first title is Returning Officer Namakkal versus NP Punduswamy. It's a 1952 Supreme Court.
Man, the only issue here is, my lords, they are relying on a rule which in itself is not published.
That's a standard rule that once election process starts,
Man,
will not
it's
interfere.
certain clarification saying that those
Anyway, this will go before a single judge.
Yes, ma'am.
All right, 2 o'clock. 2 o'clock.
Much obliged, my lords.
All right.
May I call? Supplementary list for orders, item number 1.
Item number 1, your lordship, the present petitioner has been convicted under section 302 of IPC and directed to undergo RI for life. And he's inside custody since 2011, your lordship.
11,
your lordship.
How many victims?
One, your lordship.
And what is this? Direct evidence, circumstantial?
Direct evidence. So 1, 2, 3, 4 are the eyewitness of the occurrence. Both of them quarreled with each other and he picked up a stick and assaulted the
So you're arguing for 304 part 2.
Yes, your lordship.
How many injuries?
There is plus 4 injuries out of 3 are lacerations and 1 is fracture of right parietal bone.
Fracture.
Yes.
All right. So 11 years. All right. So you say counsel for the applicant points out that the appellant has already served 11 years in jail. There is no immediate prospect of the appeal being taken up in its regular course. Although paper books are ready or not?
No, not ready.
Since paper books are not ready. In that view of the matter, in view of the judgment in Singada Singh, the court directs that during the pendency of the appeal, the appellant will be enlarged on bail, subject to the satisfaction of the trial court. Then paragraph in the main appeal, you say paper books be readied and supplied to counsel of the parties within 8 weeks to be included in the list of unclearing matters immediately thereafter.
Obliged.
All right.
He was interim granted interim bail sometime for cardiac problems.
All right.
So
It's also pointed out that the appellant was earlier enlarged on interim bail and has not violated the bail conditions. All right.
Obliged.
Right, sir. Right, sir. Right, sir.
Namaste.
For admission, item number 1. CMAPL 110 of 2015.
I am for the respondent.
All right. None appears to the applicant. Dismiss the non-prosecution.
Obliged.
Right.
Continue.
Supplementary list for orders item number 1.
None appears for the review petitioner. Dismissal on prosecution.
Read order is again is in favor of the review petition.
All right.
Item number 2.
This is also barred by limitation.
I know. Again, none appears for the applicant. Dismissal on prosecution. Right. Sir. Thank you. Thank you.
Hello, namaste.
Namaskar. Namaskar.
Supplementary list for orders item number 1.
May I please,
CMAPL
Your Lordship?
562.
May I please, Your Lordship? My Lord, this is a CMAPL petition for restitution. Look, I have glanced the earlier order dated 12/4/2022.
But you told us that the client cannot be contacted.
No, my Lord. Actually, that time the client suffered some.
You filed. You're coming new to the matter.
Yes, ma'am.
You've taken no objection to the earlier counsel.
Yes, madam. Also, I filed.
What's the main matter about?
For promotion, my Lord, regulation of service, my Lord.
No, termination, sir.
Yes, my Lord. Sorry, my Lord, termination.
You're not studied the facts. What was the ground on termination?
You know, actually, I've challenged the SAT order, my Lord. SAT order, my Lord. Actually, I am not the conducting lawyer, my Lord. Mr. T.K. Biswal is the conducting lawyer, my Lord.
Who is that?
T.K. Biswal.
So?
I am the associate.
So either you're ready or not. You have to argue the main matter, sir.
No, my Lord. Today only I have placed this CMAPL.
No piecemeal thing. We have to be ready with the main matter.
My Lord, can we adjourn some other day, my Lord?
Counsel for the petitioner, when asked whether he is ready to argue the main matter upon restoration, says that he is not the arguing counsel and one Mr. T.K. Biswal will do it. In that case, the matter, the present matter is adjourned. And he, full stop, he accordingly seeks an adjournment. You say adjourned to 21st April.
Item number 2.
May I please, Your Lordship? Your Lordship, the petition dismissed for the non-moving instruction by the previous counsel, Your Lordship. So due to communication gap. Your Lordship, I have only a very limited prayer, Your Lordship. Because of the pendency of the writ petition, the awarded amount which has been given to the petitioner was not been disbursed. That because and after the dismissal of this writ petition, I have also intimated the respondents that since they dismissed the kindly disburse me the awarded amount. So it is pending with them. They are not disbursing. So
you say for the reason stated that the order is recalled and writ petition civil 32051 of 2011 is restored to file. In the main writ petition, you say the challenge in the writ petition is to an award dated. Is it to an award?
Yes, Your Lordship. Understand.
No. Where is the award?
Award is at page 15, Your Lordship.
15.
Yes, yours.
It's an award dated 22nd July 2011, passed by the Labour Court, Bhubaneswar, in industrial dispute case number 18 of 2009. The following dispute was referred to the Labour Court for its decision. Take from page 15. The Labour Court has in the impugned award found that the termination of the services of the workmen with effect from 27 January 2006 was open petition, neither legal nor justified, unquote. However, in lieu of reinstatement, the Labour Court held that he is entitled to get a lump sum of rupees 75,000 as compensation in lieu of reinstatement and back wages, and that it should be paid within 1 month from the date of the publication of the award, failing which shall carry interest at the rate of 9% till realization. Paragraph. Considering the time at which the award was made, the court and the terms of payment, the court does not consider the impugn award to be unreasonable. Full stop. The award is accordingly affirmed. The writ petition is dismissed. Full stop. The effect of the present order would mean that the amount ordered to be paid by the Labour Court will be dispersed together with interest as ordered to the petitioner forthwith. Full stop. It will be open to the petitioner now to take appropriate steps for enforcement of the award. With the above observations, the petition is dismissed.
Deeply obliged.
Pardon, your lordship. I'm herewith filing a mention memo before this honorable bench. There has been an inadvertent typographical error in the order of the in order dated 1st of March 2023 in WPC number 1905 of 2000.
All right. Atanu instead of Tanu.
Yes, your lordship.
All right. That's your name, is it? No, no.
No, the name of the petitioner.
Petitioner. Sorry. All right. Taken on board. Corrections carried out. All right.
Grateful, your lordship.
Supplementary list for orders item number 1.
May I please, your lordship?
Yes.
I filed an application for modification. Here, it was mentioned that the order was passed by Tahsildar. Instead of that, it will be assistant settlement officer.
All right. The correction we carried out as played for.
Obliged.
All right.
Item number
should the earlier order be downloaded and the correct order be uploaded, even in the earlier matter.
Item 2 is in the same case a pray for extension because direction was given to file appeal by 1st March.
All right. The time for filing the appeal is extended by 1 month from today.
Obliged.
All right.
Item number 3.
Item 3, Lord, Mr. Agrawal is traveling and is requested for taking up this matter on 5th May, my lord.
It's a review petition?
Yes, Lord. It's a review petition.
Review for what?
The judgment. They are that not along with the review petition number 28 and 29.
All right. It is at the request of counsel, the petitioner list on 24th April, along with
Also,
review petition number
5th May, my lord.
5th May. All right.
Yes.
5th May, along with review petition.
Along with the review petition number 28 and 29 of.
He can appear virtually, sir.
No, but he is traveling now.
That's right. Wherever he's traveling, he can appear.
Another matter is here on my lordship.
5th May. All right. All right.
Yes.
Okay.
Well, I am appearing on behalf of the party.
Item number 4.
That on dated 16/1/2023, I have already overlooked the said cause list. That is a non-prosecution. Kindly restore the matter. And my lord, the matter, the case is already decided. ASO cancelled the entire.
All right. For the reason stated, the order in 31st March is recalled. January is recalled. The writ petition is restored to file. In the writ petition said the decisions in Narottam Rata. All right.
Item number 5.
Item 5 also covered by Narottam Rata judgment.
Same.
My name could not be.
All right. All right. Same order in 5 also. Only the numbers will change. All right.
Dismissal order be recalled.
Correct.
Item number 6.
Lordship, so my writ petition was dismissed for non-prosecution on 8 February 2023. Where I was absent because of there is a death in the family for which I have to.
IMFL offshore.
Yes, my lord. Shifting of the IMFL offshore that has been rejected application. Against that, I have filed this writ petition.
What's the remedy?
Shifting has been rejected by the commissioner.
Shifting request has been rejected by the superintendent.
He should go to revisional authority. Government.
I'll file a revision.
All right. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to approach the Secretary, Department of Excess.
Under section 6 of the Orissa Excise.
Under section 6 of the Orissa Excess Act. Okay. Disposed of is withdrawn with liberty is prayed for.
Item number 7.
7 also dismissed for deferred, my lord, for final hearing. There is the case is that the proceeding was filed against a dead person. That was challenged, my lord. The OSFC has filed against a dead person, my lord.
No.
The total order sheet shows that from the date of filing, the opposite party before the court below were dead.
No, but no order has been passed. It's just the proceeding has been initiated. That's all.
Yes.
So you can point out to the judge that. You can always point out to the trial judge. It's a restored to file, and then the main writ petition, you say the grievance made in the present petition is that the Orissa State Financial Corporation has initiated proceedings under Section 31 of the State Financial Corporation Act against the dead person. Full stop. This fact can be brought easily to the notice of the concerned trial court. There is no need for the court to interfere at this stage. The petition is disposed of with the above solutions. The interim order is vacated. There is no interim order.
No.
All right.
Item number 8.
But here, the CMAPL had filed for restoration of the case because when it was placed before your lordship, the conducting counsel said no instruction.
OHRE Act.
Yes, ma'am.
What's the matter about?
My lord, matter is about challenging the order of the Honorable Single Judge who has ignored the previous orders passed by this Honorable Court and has directed, your lordship will see, the impugned order is under Annexure 9, has a writ petition number bearing such and such filed by Susan Mishra is accordingly disposed of. The order connected writ petition filed by various purchasers from the power of attorney of the said Susan Mishra require no further orders to be passed. Who is also stand disposed of. The above order is passed, taking into consideration the fact that the entire constitution money has been deposited earlier before the court, which is lying in deposit in interest. Lying in deposit in an interest-bearing account, thereby no loss is caused by either to the mott or the temple, Jagannath temple. My lord, we are the purchasers. My lord,
no sale deed has been executed in your favor, sir.
Yes, but that was already decided by in the previous writ applications. Your lordship may hear it on merits, subject to what your lordship said. but no instruction is dismissed, my lord, the appellant should be prejudiced, my lord.
For the reasons stated there, and this is 1611, is it? All right. The order dated 16/11/2022 is recalled, and writ appeal 369 of 2012 is restored to file. List before the roster bench on 19th April.
My lord, one more prayer. My lord, there were two writ appeals. One matter CMAPL has come. Another is CMAPL 152 of 2023, same order.
That's taken on board, the same order listed on the same date. Correct.
Grateful, your lordship.
Item number 9.
It's a restoration, 80 days delay only plus. Because the
My lord,
bereavement in the family.
In this case, my lord, after your lordship's order, my lord, we have floated, the OSF has floated e-tender notice, my lord. And tender is fixed to 28th.
22nd.
22nd, madam. A fresh cause of action arose.
So there's nothing there. In the main petition, nothing is there. Fresh tender has been floated. So for the reason stated, the order is recalled and this writ petition is restored to file. In the main writ petition, you see Mr. Das appearing for the NHAI. OSFC informs the court that the fresh e-tender has been floated for auction.
Lords, I have prayed for a stay, Lords, present application flag B for stay.
No. This leads to a fresh course of action, and therefore the present writ petition is infructuous. It will be open to the petitioner to seek appropriate remedies in accordance with law.
Grateful.
All right.
Item number 10.
This matter was disposed of on 19th of January this year, giving certain direction to the collector, that is Puri collector.
I have received the instructions. If I may place the instruction,
right.
Please, because there was a joint inquiry conducted on 6th of March 2023 by the District Social Security Officer. It is revealed from the joint inquiry report that Shri Abhay Kumar Patnaik has been sanctioned a PMAY house during the year 2019-2020 worth 1.2 lakhs only, and the house has been constructed over an area of so and so with RCC roof. He is residing in the house with his family members consisting of his son, daughter-in-law, one grandson and one grandfather. A small pond is available behind his house, and it is found that pisciculture is being made. Free rice at 5 kg per month per member. Total 25 kg is being provided to the family. MBPY pension has been
just show us the copy of the letter.
Please,
you don't have it.
The copy.
Counsel for the states that he'll hand over to the counsel for the applicant the instructions received by him. List on
next Friday.
My lord, may I read the last order?
So you first see what he's written.
Whatever they are submitting, they are not relevant to my case. My point is that I am not able to get the basic minimum for my life requirement. It's already 60 days. They are not providing a single thing to me.
Even they don't alleged that this person was begging. He is not begging. In fact, when the
why don't you read what he's written? Then you can make a submission, sir. First,
yes, ma'am.
Always when you make an allegation and the other side is replying, you are saying, no, I don't want to see the reply.
No, I heard about that. I heard.
You don't need to read. I understood. Ask your client. You already know that what he said is wrong.
No, my lord.
Then he gives you what is written there. Will you not ask your client?
Yes.
You already know everything. Your client already knows what is written here.
No, my lord, the case is that the last sort of
if you're going to argue, we will today decide and dismiss your petition. We will say you're refusing to read the reply given by the collector. You're refusing to put to your client what the collector has said. We'll dismiss it on that ground.
I'm sorry for that.
No, if you want to argue, I'm saying please go ahead and argue. But after that, when we dismiss your application, don't then make a noise.
No, I'm not arguing, my lord. Let them file, but I wanted to point
counsel
out
for the states that he has received written instructions, copy of which he will hand over to counsel for the applicant. List on 6th April. No, sorry. 31st March. 31st March.
Item 11.
I got some inadvertent error in the order, my lord.
All right.
Corrected, my lord.
All right.
My lord, last paragraph, the appearance date may kindly be extended. appearance date 20th February, that may be extended. to
All right, the orders be corrected as pointed out. The date for appearing before the assessing authority is extended
both the dates.
Is refixed as 10th April 2023. And the date for fixing for passing the order is extended up to 31st May. Yeah, everything is given the earlier order be downloaded and the corrected order be uploaded. Correct.
Item number 12.
My lord, late piston STRE instead of.
Yeah. The correction be carried out as pointed.
Okay.
Item 13.
Item 13 also already I have filed the IAs and the order also I have given the similar order.
Right. In all these matters, the modification be carried out. Right. Same order in all these IAs. All right.
Okay.
All right.
Item number 14.
Item number 14, I have filed for modification, correction of the order. In paragraph 7 of the order, my lord, while allowing my writ petition, my lord stated that the petitioner having already paid the affirmative demand of 2.4 lakhs. It would be 10.4 lakhs. My lord. In the paragraph 1, it is.
The correction be carried out as pointed out. All right.
Item number 15.
Lord, item 15, I am just suggesting, kindly see order dated 13th of December 2022. Lord, there, in fact, there is certain inadvertent typographic from the earlier order. It is quoted here. Para 3, I have suggested to delete in para 3 of my application. That was, in fact, in the context of the previous licensee, and he was asking for renewal. In that context, that order was passed. But I am suggesting that in your lordship's order, it is not required. I have no nexus with the.
I see. So we delete para 3.
Not para 3. I have suggested in page 3. Page 3 of my application, but entire para 3 will not be deleted.
All right. All right. So the reason stated, the application is allowed, and as directed, para 3 of the order dated 13/12/2022 shall stand deleted.
Yes.
The corrected order shall read as under.
Yes.
This order now be uploaded and the earlier order be downloaded.
Yes, that grateful. The next matter.
16.
Next matter, my lord. In fact, the proposed correction which I am proposing in my application also still requires certain clarity. I have suggested, but in the copy I have just suggested it.
All right. This correction be carried out.
Lord, one more additional prayer I have here. Here, your lordship directed to dispose of the representation. The excise year is going to be over by 31st of March. Would your lordship kind enough to direct to dispose it of by end of excise year? That will. Otherwise,
can it be so?
Mr. Mahathir also will agree. The reason being, in the interest of the state's revenue, we will pay the state.
But there's hardly any days left.
They will take a decision. Well, they are going to take a decision in all these matters.
They have, all of them have prayed for carrying forward the MGQ for the next excise year. So.
All right. The decision on the petitioner's representation be given by 31st March 2023. All right.
The second one is also same. I have suggested, my lord.
All right. Second one also corrected order.
Great.
70.
Same 31st of March.
All right.